friends, welcome to my channel. Today we're reading the Law of Evidence, Indian Evidence Act 1872, and we're going to read these three expressions. Number 1, may presume. Number 2, shall presume, and number 3, conclusive proof. And the book of the language is very good. Amazing language. So let's begin. Section 4 of the Indian Evidence Act 1872 provides may presume. So the language of the word used whenever it is provided by this act that the court may presume a fact, whenever it is provided. So here the word provided is used for by this act, that the court may presume a fact. It may either regard such fact is proved unless and until it is disproved, or may call for proof of it. So it may regard, may presume. May presume means it may regard it is proved unless and until. The word unless and until is used, or it is disproved. So it is open for disproving, or may call for proof of it. So there are two options. Court may presume a fact. It may either option number 1, regard such fact is proved. But there is a condition. It may regard such fact as proved only on the conditions that unless and until it is disproved. And option number 2, or may call for proof of it. Then comes shall presume, whenever it is directed by this act. Now here the wordings are different. May presume we find whenever it is provided. We find the word provided. But in shall presume, whenever it is directed, the word directed is used here. And the difference between generally may and shall is that, well, while may is the directory in nature, means the court is at liberty to follow or not follow. For example, shall is mandatory, compulsory. Okay. Then comes shall presume, whenever it is directed by this act that the court shall presume a fact, it shall regard such fact is proved, and unless and until it is disproved. So almost same, but there is a lot difference between both these expressions. And Indian Evidence Act is very technical, so you have to be careful while studying this act. Conclusive proof. Then conclusive. What do we generally mean by the word conclusive or conclusion, or what do we generally mean? It means finality, final, something which is final. So when one fact is declared by this act to be conclusive proof of another, the court shall on proof of one fact regard the other as proved. On proof of one fact. So the essential element is there must be two facts, first of all. Second, the fact is declared by this act to be conclusive proof of another. One fact is declared to be conclusive proof of another. The court shall on proof of the one fact regard the other as proved. On proof of number one fact regard the another as proved, and shall not allow evidence to be given for the purpose of disproving it. And there is no there shall not allow shall. The word against shall is used here, which is a mandatory in nature. Not allow evidence to be given for the purpose of disproving it. So it is final. The word presumption means, so after this we have to observe the meaning of each and every word used here. For example, may, shall, presume, presumption, and conclusions. So first of all, we're going to read the meaning of the word presumption. The word presumption means things taken for granted. Presumption is like a proposition. We already know it is kind of assumption. In the law of evidence, the word presumption is used to designate an inference. Affirmative. It may be an inference. Okay, designate an inference. The language of this book is very good. Very standard language. It's used to designate an inference to affirmative or negative. It may be affirmative, means positive, or it may be a negative inference of the existence of, and that inference may relate to what? Fact. Existence. What kind of facts? Existence of some fact drawn by tribunal. Tribunal means here the court. By a process of probable reasoning. The process is used here is probable reasoning. Why it is probable reasoning? Probable. Probable means with a probability, on the basis of probability. It's not something just probable. We know the general meaning of the word probable. Probable reasoning. This may be, this may happen, this may probable. Probability. The term presumption in its largest and more comprehensive significance, largest and most comprehensive significance may be defined, wherein at the absence of actual certainty of the truth or falsehood. When there is absence of something, what is actual certainty? Certainty which is of actual nature. So means there's no certainty. Absence means the absence of actual certainty implies what? there is no certainty in this process. So of what? Truth. It may be of truth or it may be of falsehood, and it relates to a fact. That's why truth or falsehood of a fact or proposition. And in interference, affirmative or disaffirmative of the truth or falsehood is drawn. So in this case, when there is the absence of actual certainty of truth or falsehood of a fact or propositions, they have to draw an interference. Okay, the interference may be affirmative or disaffirmative. Affirmative means positive or disaffirmative means not positive. That means negative of that truth or falsehood is drawn by a process of probable reasoning and from something which is taken for granted. Okay, it has, however, rarely employed in jurisprudence as its extended sense. Extended sense means largest sense, like presumptive evidence. It has there obtained a restricted legal significance. Like presumptive evidence, it has obtained a restrictive legal significance. It has obtained a legal significance, but which is of restricted nature, restricted, not extended. And it is used to designate an inference, affirmative or disaffirmative, of the existence of some fact drawn by a judicial tribunal by a process of probable reasoning from some matter of fact either judicially noticed or admitted or established. The matter of fact may be judicially noticed, may be admitted, or may be established by legal evidence, and the evidence must be of legal nature, legal evidence to the satisfactions of the tribunal court. Okay, presumption are drawn from the course of nature. For instances, this is the examples of presumption: night will follow day, the seasons follow each other, that dangers from a mortal wound, and the like, or from the course of human affairs, from a familiarity with the ordinary springs of human actions, from the uses of society, domestic relationship, and transaction in business. In short, a presumption is an inference of fact drawn from other known or proved facts. So it is of law under which court are authorized to draw a particular inference from a particular fact unless and until the truth of such inference is disproved by the other evidence. So in very simplest language, you can say that presumption in certain kind of assumptions which is yet to be verified or tested, but okay, this is what yet to be verified or tested. So the court may draw some certain kind of presumption. So may presume. The word presumption left it to the court to make or to not make presumptions according to the circumstances of the case, and it's entirely and in most of the cases depends upon the circumstances of the case, and it is the discretion of the court to make or not make presumption. The word used may and not shall. The word used here is may and not shall, and there is a lot difference between the word may and shall. A court where it may presume a fact has a discretion to presume it proved. Discretions. The discretionary power are given in the court. So, to presume it to proved or call from confirmatory evidence that the circumstance require. In such a case, presumption is not a hard and fast presumption. Okay? Not a hard and fast presumption is incapable of rebutted. Incapable of rebutted means they are capable of rebutted. A presumption jury sat the jure. Here, the court is free to presume or to not to presume any fact or not. Section 19 of the Indian Evidence Act provides that when a document purporting to be 30 years old is produced from proper custody, the court may presume that the purporting to be 30 years old is produced from proper custody. The court may presume that the document was signed and written by the person by whom it purported and is said to have been written and signed. So the word used here is may presumed. Okay, there is no certainty. It may be rebutted. If a document produced before a court is 30 years old, the court may dispense with the proof of it and read the document in evidence without calling for the proof of it. The court may also call for proof of it and order that document will not be read in evidence without being proved. So that court has the power either to call for proof of it or to presume it as a proof. Under may presume, it is open to the court upon proof of a marriage on a date. This is another example. Under may presume, it is open to the court upon proof of a marriage on a certain date, either to regard as proved the subsistence of the marriage on a subsequent date and it should be disproved, or else to call for proof of it. This is the case Ismail versus Momin. Once the factum of marriage is proved, everything necessary to validate such marriage, including the observation of essential ceremonies, shall be presumed, because once the factum of fact, the real fact of the marriage is proved. Everything necessary to validate such merits, and everything necessary to validate such merits, including those may include the observation of essential merits, shall be presumed. Shall, the word shall is used, shall be presumed, particularly where the legality of the validity of marriage are not impugned either in the pleading or in the evidence in the grant of non-performance of necessary ceremonies or otherwise. Particularly in what cases? Particularly where the legality or the validity of marriage are not impugned either in the pleading or in the evidence, and the evidence are also perfect, on the grant of non-performance of necessary ceremonies or otherwise. This under grace Sridhar Day versus Kalpana D. And then comes the meaning of the word shall presume. In this, no option is left to the court. There is no discretionary power on the power is given to the court, but it is bound to take. Bound means not mandatory something. To take the fact as proved until the evidence is given to disprove it. And the party interested in disproving it must produce as evidence if he can. And the parties must produce as evidence if you want to disprove it. For instance, number 1, the genuineness of a document purporting to be the Gazette of India. 2, the genuineness of a document purporting to be the Gazette of India. Okay. 2, a document called for and not produced was duly stamped. A document called for and not produced was duly stamped, attested, and executed, or that circumstances bringing an offence within the exceptions to the Indian Penal Code do not exist. The first, self-presumed, is to found in the sections 79, 80, 81, 83, 85, 89, and 105. Whenever there is a presumption to the effect that the court shall presume effect, the court cannot exercise its discretions. The court has no discretionary powers in those cases because it is mandatory provision. Shall means mandatory. There is no discretionary power on behalf on behalf of the court. It is compelled to take the fact as proved. It shall have to presume the fact. Compelled word is used here. Compelled to take the fact as proved. It shall have to presume the fact. But in this case, the court will be at liberty to allow the opposition party to liberty. But there is also same as the court will be at liberty to allow the opposite party to adduce evidence to disprove the facts of presumed and if the opposite party is successful in disproving it, the court shall not presume the fact. Then comes the Indian evidence. Indian evidence, the word shall presume indicate that presumption therein is unrebutted. Presumption therein is unrebutted. Okay. Section 89 of the shall indicate that the presumption therein is unrebutted. Section 89 of the Indian Evidence Act provides that the court shall presume that every document called for and not produced after notice to produce, attested, stamped, and executed in the manner required by law. That the court shall presume that every document called for and not produced after notice to produce, attested, stamped, and executed in the manner required by the law. So this is an examples of presumption. Then comes conclusive proofs. When the law says that a particular kind of evidence will be conclusive, that fact can be proved either by that evidence or by some other evidence. Either by that evidence or by some other evidence which the court permits to recur. The court may permit or the court may recur. When such other evidence is adduced, it will be up into the court to consider whether upon that evidence the fact exists or not. On the other hand, when evidence which is made conclusive is adduced, the court has no options but to hold it the fact exists. There is no difference between conclusive proof and conclusive evidence. These cases they occur when it is against the policy of government or the interest of society that a matter should be further up into dispute. Thus, judgment of certain courts as conclusive proof of the matter stated in them. A birth during a valid marriage with certain exceptions is a conclusive proof of legitimacy. So this is a best example of these cases. A birth during a valid marriage, so the marriage is valid, so the birth of a child during a valid marriage is with certain exceptions. Exceptions may be allowed. Exceptions are also yours, but generally it is presumed is a conclusive proof of legitimacy. When one fact is declared by the act to be conclusive proof of another, the court shall unprove one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Section 41, irrebutted presumption of law are called conclusive proof. Section 41, irrebuttable presumptions of law are called conclusive proof. When one fact is declared by law to be conclusive proof of another, the court cannot allow evidence to be given in rebuttal. Okay, there's no chances. There is no scope for chance. Irrebuttable presumptions of law are inferences which the law makes to peremptorily that it will not allow them to be overturned by any contrary proof, however strong. Okay, That's the case. This is the strongest of all presumptions, strongest of all presumptions. Whenever it is mentioned that a fact is a conclusive proof of another fact, the court has no discretion at all. It cannot call upon a party to prove that fact, nor can it allow the opposite party to adduce evidence to disprove the fact. Section 41 of the Evidence Act provides, inter alia, that a final judgment, order, or decree of a competent court in exercise of matrimonial jurisdiction is a conclusive proof of that legal character. This is another example. Section 41 of the Evidence Act provides, inter alia, that a final judgment, order, or decree of a competent court, the court which is of competent nature, competent court, in exercise of matrimonial jurisdictions, and the jurisdiction is matrimonial, and matrimonial jurisdiction is a conclusive proof of that legal character. Then comes problem. Distinguish between may presume, shall presume. According to the definitions of Best, the term presumptions in its largest and most comprehensive significance may be defined to be an inference, affirmative or disaffirmative, of the truth or falsehood of a doubtful fact or propositions, the fact which is doubtful, or proposition which is doubtful, drawn by a process of probable reasoning from something proved or taken for granted. Okay, a presumption means a rule of law that court. Presumptions means a rule of law. Okay, that court and judges shall draw a particular inference from a particular fact or from a particular evidence, unless and until the truth of such evidence is disproved. Presumptions are drawn from the course of nature, for instance, that the night will follow day, the summer will follow the winter, that endures from the moral wound, and the like. So, in the inferences or presumptions are based upon the wide experiences of a connection existing between two facts. They may be drawn from the course of human affairs, from the uses of society and transactions in business. Examples: a watch of Ram is stolen, and soon after it is recovered from the possessions of Siam. So the cases here, this example will best illustrate the points. For example, a watch of Ram is stolen. Okay, there was two persons, Mr. Ram and Mr. Shyam. So a watch of Ram is stolen, and soon after it is recovered from the possessions of Shyam. There shall be a natural interference presumptions that Shyam either stole the watch to himself or received it from some thief, knowing it to be stolen. So there may be two kinds of interferences. Number one, Shyam either stole the watch himself. Number two, or received it from some thief, knowing it to be stolen. Whenever it is provided that the court may presume a fact, it has the discretion to presume it is proved, or to call confirmatory evidence of it. Discretions. May. The word may is used to, so it has discretions to presume it is proved, unless and until it is disproved, or may call for proof of it, or to call confirmatory evidence of it, as the circumstances may require. In such a case, the presumptions is not hard and fast presumptions incapable of rebutted. It is rebuttable presumptions, not irrebuttable presumption, and we have find in the case of conclusive proof. Thus, the court may presume that a message forwarded from a telegraph office corresponds to a message delivered for transmission in the office, section 38. This is an example. Then, or the court may presume that a certified copy of foreign judicial records is genuine. Certified copy of what foreign judicial records is genuine and accurate, section 86. Or in either case, the court may call for further evidence. But when it is provided that the court shall presume a certain fact, the court has to take the fact as proved unless and until it is disproved. In such a case, the court has no options but shall. The word shall is used here. The court has no options. There is no discretionary power on part of the court, but to take the fact as proved unless the party interested in disproving it produces sufficient evidence for this purpose, and that party disproving it must produce evidence which is of course of sufficient nature. Thus, the court has to presume the genuineness of every document purporting to be in purporting to be the London Gazette or Gazette of Government of India or the Gazette of any local government, section 81, etc. Then comes kinds of presumptions. Then number one, presumption of law. Presumption of law or artificial presumptions are interferences or propositions. These are of course interferences or propositions established by law. The interferences which the law purport to preemptorily requires to be made whenever the facts appear, which is assumed as the basis of that inference. The presumption of law are in reality rules of law, rule of law and part of the law itself, and the court may draw inference whenever the requisite facts are developed in pleading. Presumption of law are based, like presumptions of fact, on the uniformity of deduction, okay, which experienced proves to be justified. They differ in being invested by the law with the quality of the rule, which directs that they must be drawn. They are not permissible like presumptions which may or may not be drawn. The presumptions of law again differ in their force as they are rebutted or as they are again differ in their force as they are rebuttable or irrebuttable. So this may be presumption of law. There may be two kinds to their force, rebuttable or irrebuttable. As to presumptions, As to the former, the presumption shall stand good only until it is disproved. The later case or rebuttable presumptions to law holds conclusive. Conclusive means final. So, presumption of law, artificial presumption is a kind of law. Presumption of certain kind of law or artificial presumption are inferences or propositions established by law. The interferences with the law preemptorily recurs to be made whenever the facts appear, which is assumes as the basis of that inferences. Okay, and these are in reality rules of law. Then comes the presumption of law of two kinds: irrebuttable or conclusive. Rebuttable presumptions of law. Then irrebuttable presumptions are conclusive or rebuttable. Conclusive will know for any final. Irrebuttable presumption of law are those legal rules which are not overcome by any evidence that the fact is otherwise. A well-known instances of an irrebuttable presumption of law can be found in Section 82 of the Indian Penal Code. This is best example because we all know we all have read in the IPC and it's very easy. Wherein it is laid down that nothing is an offence which is done by a child under 7 years of age. So it is a rebuttable presumption that cannot be rebutted because the child is of course under 7 years, and it is presumed that it is of immature understanding. But between 7 and 7, but above under 7 is okay. But above 7 and below 12 years, it is considered there is presumption because a child may be of mature understanding or maybe of immature understanding. But below 7 years, there is no just. It is a rebuttable presumption, and this is established by law, by under the provisions of law. For example, Section 82. This is the provisions of law of Indian Penal Code. The rule of estoppel dealt in Section 115, 116, 117 of the Act are under examples of this sort of presumptions. The rule of estoppel, which is dealt under Section 115, 116, and 117 of Indian Evidence Act 1872, are also under examples which you can and we can write in exam. Okay, then comes to rebuttable presumptions. This kind of presumption arises when the presumption of law or certain legal rules. These are certain legal rules to defining the amount of evidence requisite to support a particular allegations. Okay, which facts being proved may be either explained away or rebutted. This may be explained away or this may be rebutted by evidence to the contrary, and these are rebuttable because there are chances, there is a scope. You can give evidence and you can change the. You can rebut it by evidence to the contrary, and the evidence must be provided, of course, to the contrary, but are conclusive in absence of such evidence. In absence of such evidence, it is only conclusive on the conditions that in absence of such evidence. If nobody is there to produce the contrary evidence, then it will be conclusive. For example, but there are scope and chances that you can produce evidence and you can change the game. For example, a man is presumed innocent until he is proved guilty. A child is born. For example, a man is presumed innocent until he is proved guilty. So, this is the best example that I can give you. A man is presumed innocent. An accused person, for example, he is always presumed innocent until and unless he is proved guilty, and he must be proved guilty. Okay, so an accused person is always presumed innocent until he is convicted or he is proved guilty. A child, if born in illegal wedlock, shall be presumed to be legitimate, and one who questions its legitimacy must disprove it, and the burden of proof lies upon the person who questions it. Section 107, 108, and 112 are examples of this sort of presumptions. Then comes presumption of fact. Presumption of fact or natural presumptions are inferences which are naturally and logically drawn from experience and observations of the course of nature. Course of nature means it is a fact, not something law. The constitution of human mind. So, what are those observations? Presumptions of fact or natural presumptions. These are also known as natural, not artificial, as opposed to artificial, which we have already read. In case of law, are inferences which are natural and logically drawn from nature, which are drawn naturally and logically, drawn from experience and observations of the course of nature. The constitution of human mind, course of nature, and the constitution. This is not constitution of India, but constitution of human mind. The springs of human actions. Springs, okay, the linkage, the continuity of human action, the uses and habits of society, all these things matters. Section 104 of Indian Evidence Act and the illustrations and other sections are examples of presumptions of fact. Sections 86, 87, 88, and 90 also deal with the presumption of fact. These presumptions are generally rebuttable. Rebuttable means there are chances you can produce documents, you can produce evidence to the contrary, and this can be disproved. Okay, so presumptions on any fact is purely an inferences of that fact from other facts that are known. It is an act of reasoning. Presumptions of fact, maybe it is an act of reasoning. It is very important. See this line. It is an act of reasoning. Okay, presumption of fact. Presumption of fact may be said to relate to things, persons and acts. So, two things. Number one, person. Number two, facts. This is important. no, persons and acts, and thoughts of intelligent agents, and also thought of intelligent agents, persons, acts, and thoughts of intelligent agents. With respect to things, it is an established principle that conformity with the ordinary course of nature is ought always to be presumed. Conformity in the ordinary course of nature. The same rule extends to persons, acts, and thoughts of intelligent agents. Include all psychological facts or internal facts. Psychological facts or internal facts are also included in those cases. Not only the external surroundings and circumstances, but also human mind. And psychological fact or internal facts. Under this class, most of the important inferences are drawn from the ordinary conduct of mankind in the mutual feelings or impulses. Again, mutual feelings or impulses of human nature. This is what this is what relates to the psychology, as also from the customs and habits of society, and also our external world of society and the surrounding circumstances and effects and everything that matters to human life. Then 3. Mixed presumptions. Mixed presumptions or presumptions of mixed law in fact holds an intermediate means intermediate place between two former presumptions and consist chiefly two former presumptions means fact and law. Intermediate and consist chiefly of certain presumptions to inferences which from their importance attract as it were the observations of law. These sort of presumptions are not being dealt with in Evidence Act. The Indian Evidence Act has made several provisions for presumptions of fact and the presumptions of law. Sections 4 of the Act, however, giving a directions to courts as to how to proceed under those sections to control them. Then comes the problem. Distinguish between presumption of law and presumption of fact. Problem, this is summary. This is like summary, okay? If I don't read, there will be no harm at all. So we read this 3. Okay, if you find my language, okay, so what can I say now? If you like my videos, please do not forget to subscribe. And I cannot say anything except this. That's really interesting. I love Indian Evidence, but tough also and very technical.